Well, hello students and welcome to the week 4 lecture for LW305. This week we're covering issues with lawmaking bodies, and specifically we're focusing on state lawmaking bodies as the institutions that make written laws in our jurisdictions. It's going to start off by looking at the legitimacy of the rule of law and then move through some other aspects of lawmaking processes and talk a little bit about courts. A little bit different. This week, the lecture will be delivered by Anita Jowett, who's a former deputy head of school of USP Law School, is the author of the textbook from which a lot of your readings are coming from for this course, and who has previously taught this course for many years, and so is very much an expert and somebody whose views are worth listening to. So without further ado, I'm going to pass over to Anita to talk about the legitimacy of the rule of law and take it from there.
With a discussion of legitimacy of the rule of law, which gives you useful theoretical underpinnings. And the two main readings here are Hughes and then Graham Hassel. And the Hassel reading is one of my favourites that I keep on going back to almost 15 years after I first read it. It's just, I find it a very good reading. The idea of the rule of law, the idea that the legal system actually governs us, comes down to a belief in legality, which I personally find really interesting. And the belief in legality, you might see it referred to as legalism or legal ideology, legal culture. But it's a belief in the power of the law. It's a belief that state law both should govern us and does govern us. And so it's a belief in the political world, how we think the political world should operate or should be understood. That if we believe in the rule of law, if we believe in legality, in legalism, we actually believe that legal systems are significant or should be significant in governing our day-to-day behaviours. The idea of legalism in modern democracies derives its legitimacy or its sense that, well, this is actually a real idea and a good idea from a combination of belief in rationality and as well habit or social practice. Expanding that a little bit, what do we mean by belief in rationality? Remember as well, this is theoretical underpinnings. Most people would go back to Weber, a German sociologist from the early 20th century. He says that modern democracies and legalism that state order can derive its legitimacy from three grounds. The first is rational grounds. So rational grounds come from a belief in our constitution, the normative rules that set up frameworks to give various people the right to issue commands. And because these people under the constitutional framework have the right to issue the commands, the flip side of that is the other people under the Constitution have the responsibility to follow the commands. This, relating it back to other theoretical frameworks from Topic 4, is very closely linked with Etzione's conception of society, of civil society. Rationality or rational grounds of authority are not the only grounds we can find, though. Legitimacy can also stem from traditional authority, which is from habits and practices from a social group that have been there for a long time. This looks very much like custom, and again it can be linked to Etzione's conceptions of society. Good society relies largely on traditional authority. And Weber also says the third ground of legitimacy is charismatic grounds. So it is the devotion to a particular person or individual. And I think an example of a charismatic leader in Vanuatu at the moment would be, it's almost a cult of personality, we could say, around Ralph Reagan-Vanu, who's really managed to capture young voters. I think it's a combination of rationality and charisma, but certainly there's a lot of charismatic authority there as well. And again, this maybe more relates to Etzione's good society. Charismatic authority alarms me somewhat because a great example of a charismatic leader would be Hitler. So charismatic authority can also tie very much with prescriptive states.
And for those of you keeping tabs at home, the definition of a prescriptive state would include a dictatorship. And we've seen some challenges around the region with charismatic leaders who might have held office for many years, say in Samoa, or who've held office for the last 10 to 15 years in Fiji. We might see some of the challenges for charismatic political leadership in the US arising through Donald Trump. We might see charismatic leadership challenges arising in Papua New Guinea. But then, of course, it is often charismatic leaders that people follow who are good-intentioned, who can lead us to greater things. Perhaps the challenge for charismatic leaders is knowing when is best to retire, which can be a problem if you've broken many laws over the years that you were governing, and retirement perhaps means prosecution and imprisonment. You might be tempted to hold on to office for as long as possible, which doesn't generally have good consequences for the legitimacy of the rule of law or for our societies.
Now, this theoretical grounding of a belief in legality, in theory, a belief in legality in a modern constitutional democracy, as we find in all our Pacific states, should be resting on rational grounds, is really problematic. Because, as Hughes argues, in the Pacific, rational authority is not strong. However, traditional or charismatic authority is strong. And we can tie this back to Etzione for some of the answers there for why rational authority is not strong, whereas traditional or charismatic authority is strong. When rational authority is not strong, this undermines legalism. So tying back to your issues, this gives you some theoretical explanation for discussing lack of debate in Parliament, corruption, and as well the lack of political will from elected leaders to represent national interests, and instead either represent personal interests or operate on quite a tribal, localised manner. Hughes, as well, and this then comes up in topic 6, says in an environment where rational authority is not strong, but traditional and charismatic authority is strong, this actually allows potential for the development of Pacific jurisprudence in which traditional authority is integrated with state authority. And he was writing this almost 20 years ago. It's maybe a research agenda for the Pacific law. Interesting point. Now, this legitimacy, which already said, it comes from both rational grounds and habit or embedded social practice. We can see that rational authority is weak, so legalism is on shaky grounds because of the weaknesses in rational authority. Does legitimacy then derive from embedded social practice? So what people actually do in their day-to-day lives. Now, if we think theoretically about embedded social practice, we might refer to the social contract. So the social contract is a fictitious contract. None of us actually sign contracts as citizens, but it's a fictitious conceptualization of how nation states operate and how power ends up being given to the legislature, to the government. And the basic idea is that rational individuals, all of us as citizens, give up some of our freedoms to the political order in order to get the benefits of political order. This is the idea that if there wasn't political order, we'd just be in chaos. There'd be no rules governing anything. And so we couldn't have any sort of development, any sort of going forward. This notion of the social contract, and there are various theoretical underpinnings. So Hobbes and Locke are the two usual sort of 16th, 17th century philosophers that are referred back to. We now see reflected in our democratic constitutions, with the idea, and again it might be a fictitious idea, that elections represent the will of the people. And through the process of elections, the people both get to make sure that the political order reflects what they want, and as well, the people exercise the ultimate control on government. I find this really quite problematic, because if this is the theoretical or part of the theoretical underpinnings of our state, of legalism, of the legitimacy of the rule of law, we've already seen weaknesses in rationality. Embedded social practice from this fictitious idea of the social contract as it's reflected in our constitutions, where electoral systems are not perceived as being particularly strong, where does that leave us when it comes to the legitimacy of the state? Certainly from my day-to-day life, my experience of living in Vanuatu is that the law is frequently treated as guidelines rather than actual rules that must be followed, which can lead to all kinds of frustrations. And so that level of embedded social practice, just do people generally follow the law in their day-to-day behaviours in a maybe semi-conscious manner, I also find problematic. So what we're ending up with is legitimacy of the rule of law in general being quite weak. Hassel quotes Habermas with the idea that citizens should always be able to understand themselves as authors of the law to which they are subject. In the Pacific, in your countries, can we say that people understand themselves to be authors of the law? Or is there a disconnect between what the legislature is doing and what the people want to have happen? How can we close this disconnect? A bit of a summary as well of Hassell's, and more on Hassell's theory, is that he describes legitimacy as the acceptance of the foundational principles of the state. If people see the state and government as having legitimacy, then there'll be a sense of constitutional unity. I'd actually put that first. Constitutional unity leads to legitimacy. Weaknesses in legitimacy stem from a weak initial social contract. So the idea that constitutions in many countries do not reflect existing social order, and as well poor performance of the law. So the law not actually operating on a day-to-day level. Where there's concerns about the validity or fairness of the electoral system, the social contract is undermined. Where there's concerns about politicians not acting in accordance with policies, the social contract is undermined. Where external interests are seen as driving local development, the social contract may be undermined. It depends on whether people agree with the external interests or not. But this does, I think, create a really potentially dangerous environment. If legalism and the rule of law is undermined, and the social contract is undermined, and the law is not actually operating on a day-to-day level particularly well, then legitimacy of the state is undermined. And this raises a quite concerning question. Are coups a rational response to a fundamentally broken system? Skipping through really quickly a couple of slides, these issues are not only common to the Pacific. I think maybe 20 years ago, or maybe around 2000, there was a lot of talk about the arc of instability in Melanesia and failed states and failing states in the Pacific, basket case countries, as if our post-colonial Pacific countries, and we could look at the post-colonial African countries, were just hopeless. Right now, I think there's really big questions being raised about democracy globally. And the Brexit in the UK and the rise of Trump in America raises real questions about democracy. So globally, there's a crisis of institutional legitimacy where the elected representatives are seen as elitist and unaccountable. Just as we might talk about in Solomon Islands or Vanuatu or Fiji about our MPs going off doing whatever they want and being unaccountable, this is also the conversation in America and England at the moment. And so populist insurgencies, people expressing their voice in ways that seem to be counter to what the elite wants, are emerging. So the Brexit being an example of that, Trump receiving the Republican nomination being an example of that. The idea that national sovereignty has lost its meaning. Now, we used to think this was about post-colonial countries where we gained independence, maybe somewhat reluctantly. National sovereignty was maybe thrust on us, and we're not sure what it means. National sovereignty is being questioned as to what it means in England and America as well. So it's a global issue. I also find this really interesting. So philosopher kings as an idea going right back to Plato, which saying that, you know what? We shouldn't be putting things to referendum. We shouldn't be asking people to participate very much in democracy. We shouldn't be asking the people. Instead, we should be relying on the people to select the best elected representatives possible And then for these elected representatives to apply their intellect, expertise, experience and beliefs in the best interests of the constituents. This is absolutely a position that can be taken, and a position that certainly some of our members of Parliament throughout the Pacific take. It's also really problematic because if we can't rely on people to rationally express their views through referendum, can we rely on people to rationally select the best qualified representatives? If we can't rely on the people to rationally select the best qualified representatives, then how is democracy operating? Certainly, the idea of politicians as philosopher kings, Plato's ideas, the idea of representatives making all the decisions for us, applying their intellect, expertise, experience and beliefs, this sort of philosophy has been used to support the idea of dictatorships, benevolent dictatorships. But really, what's wrong with it? If people are not sufficiently knowledgeable to know what's best for the country in terms of issues, if people are not sufficiently knowledgeable to be able to select the best elected representatives. These are kind of big, scary questions, but I think they're questions that globally we're going to be struggling with in the next little while. Coming back, so some really big picture scary stuff. Coming back to Hassel, just as the last point, the grounding of legitimacy in constitutional assent. Hassel talks about this being a real problem. And in Pacific Island countries where there's lots of political instability, he says that this indicates a fundamental disrespect for the law and its origins. And his argument is that constitutions were rarely founded on the consent of the people. I think Solomon Islands, if you look at historical readings, you can certainly argue this. I'd point out that this isn't the case across all countries. Samoa makes a nice contrast here. Kiribati also makes a nice contrast. The American states that have got built into their constitutions regular constitutional conventions to review the constitutions also make a nice contrast. But certainly, Solomon Islands seems to be going through this process of trying to find legitimacy through developing a new constitution. Vanuatu seems to be going through this process of legitimacy through a referendum on the constitution. Fiji certainly attempted this process in 2007 through to 2009, but then the public didn't want to participate. And then we end up with the constitution that the public didn't really participate in. This leads, I think, to a number of really interesting questions about the legitimacy of Parliament, the operation of Parliament, as to the degree to which constitutional assent exists in your country, how constitutional assent can be generated. One reading I'd like to point out, I think it's really important, is by Brant Cotterill, Yashgai and Anthony Reagan. Yashgai and Anthony Reagan should be familiar to many people who've looked at Pacific constitutions. They've been involved with so many of them. Interpeace, it's a big book online, Constitution Making and Reform, Options for the Process, about ways in which legitimacy through participation may be able to be developed. Okay, so that Hassel, Hughes, Weber is giving you more theoretical underpinnings for some of your topics about the operation of Parliament. It is often a good idea to be able to intertwine current issues with theoretical underpinnings to add some depth to your explanation. So Hughes, Hassel, Weber, and then of course they relate back to Etzioni, do give you some of those theoretical underpinnings.
Okay, just some handy information for some of you on your individual assignments or even your group assignments.
You may want to focus on just a single provision within the law. So one of the questions was, I want to look at Constitution provisions on freedom of religion. Can I just look at that, or do I have to look at everything? Something like that, because the Constitution covers so many different things, you'd want to just look at the provisions on freedom of religion. So you can narrow like that. A question, can I look at a bill? Because a bill hasn't been brought into operation yet, you don't have material on maybe why it's failing to operate. So it does make it a little bit more difficult, but you can certainly do a speculative analysis it looks like Parliament's going to respond to this social issue. However, we need much more than just the law being passed by Parliament. We also need all of these things, sort of understanding, appropriateness, and so on and so forth, in order to make the law work well. It might be more difficult, but depending on the law you choose, you can use experiences from other countries with similar laws and comparative analysis as well to help you out. Yeah, I think very few limits here. Do choose an area that you are interested in. I think the most important work that I want to point out, there's a short reading by me on the socio-political context of lawmaking in Vanuatu that is a demonstration of pulling together theoretical material, sort of the Etzioni type of framework, with reading showing why Parliament in Vanuatu isn't working as well as it should. Maybe more, and you could certainly use that as an example as background material or maybe as comparative material. Maybe more interestingly, the National Integrity Systems Assessment from 2014 of Vanuatu. This is a book and it is quite broad, but it is, I think, quite interesting because it gives you a number of potential options for research approaches that you can either copy or draw from. As researchers, most of us don't start off with something absolutely original. Instead, we find other work or existing frameworks, and we either duplicate that research in our own jurisdiction, or we use frameworks other people have developed, and we apply them in our own jurisdictions and contexts to give that new and original research. And the NIST study, it's a global study, been done in more than 100 countries worldwide, is, I think, a really useful research approach that can be used. If we conceptualise political integrity in Vanuatu or any of our constitutional democracies, we see that elections are the mechanism that gives us the legislature, and then by and large the executive is directly drawn from the legislature. There are some variations with presidential elections and so on. But the link between elections giving us the legislature then giving us the executive is the most common model. On the outside of this, in Vanuatu, we have political parties. Political parties don't exist across all Pacific countries, and I'm not sure if I've got anyone from Tonga in the class at the moment, but if anyone's been following the attempted motion of no confidence. Yesterday there was an attempted motion of no confidence in the Prime Minister for trying to claim that somebody was leader of the opposition. Given that Tonga doesn't have political parties, this led to all kinds of drama. But political parties are a way of mediating the elections. In theory, political parties determine the policies that people then vote on in the elections, and which are then followed through. The policies are then followed through by both the legislature and the executive. I say in theory because we already know that political parties and policy platforms are problematic. Now, underpinning all of this, of course, is the people as the ultimate check. The people get maybe some of their ideas of how to vote or the policies on which they can vote via political parties and political party campaigning. This then gets transferred in theory through to the elections, which then gets transferred through to the legislature and the executive, the government, in theory. This is Vanuatu's model, similar, if not exactly identical, across the Pacific. The actual operation of this model is really problematic. We already have seen good society versus civil society. There's issues of big man politics, so this maybe charismatic authority or traditional authority affecting how you vote. It also leads to localism of decisions, constituency development funds in Solomon Islands and MPs' allowances in Vanuatu as much more of a traditional mechanism of maintaining support amongst people, which doesn't necessarily sit very well with governing in the national interests. It actually leads to a very localised political system. It also creates issues of rationality or policy not being a particular feature of gaining support. And any attempts to strengthen the social contract to try and develop embedded legalism is hindered by inadequate rules in a number of areas. This comes from the National Integrity System report. There are more than 100 recommendations, so this is only a small selection of the issues relating to the operations of Parliament. So in Vanuatu, we find political instability and lots of fragmentation. I'm not sure how many political parties there are in Parliament this time around. Last time there was something like 17. There's also issues of the connections between MPs and the electorate are weak. So once people get voted in, there's no real policy connection between MPs and the electorate. And the connections are often based on gift giving or traditional one-top type of mechanisms rather than policy. There's also a lack of transparency in executive policy and decision making. So Council of Ministers' decisions and minutes are fully secret. We don't know what they're making their decisions on. And given that almost all bills are government bills originating from the executive, this lack of transparency is really affecting the lawmaking process. The legislature's capacity to act both as a lawmaking body and as an accountability body through the use of committees such as the Public Accounts Committee and select committees examining legislation is really weak. There's little confidence in the integrity of the electoral process, largely due to weaknesses in the electoral roll. There's no regulation at all of political parties, including funding and elections expenditure, statements on policy, and so on. So, whilst we've got this model of what political integrity is meant to look like, this summary of very specific concrete challenges, rather than theoretical challenges, is undermining Vanuatu's environment. Now, some of these challenges, you might go, yep, that applies in my country. In fact, this looks quite like my country. For some of you, might be going, well, political instability, fragmentation isn't a problem in my country. Instead, we've got the other extreme of too much stability. Maybe Samoan students might argue that.
Of course, after the issues arising in 2020 and 2021, Samoan students might no longer argue that they have the most stable democracy in the Pacific.
Now, the NIS, as I said, makes more than 100 recommendations. This is a short summary of the recommendations. To deal with political instability, we should limit reasons for filing motions of no confidence, and we should introduce party discipline with financial penalties for floor crossing. To address connections between MPs and the electorate and gift-giving rather than policy connections, we should look at capacity building, both of MPs and voters, review standing orders to allow more time for consultation, so actually create an environment in which the rules force time for consultation. We should also review MPs' allocations to get rid of this vote-buying type of environment. Building capacity of political parties, improved accountability of how money is being spent. In terms of transparency, given we deal with coalition governments in Vanuatu, coalition MOUs should be published, and cabinet minutes and decisions should also be published. These shouldn't be secret. Reports tabled must be listed, and they must also be made publicly available. Capacity building in the form of a Public Accounts Committee, particularly in respect of the Public Accounts Committee, is also really needed. With the electoral process, the electoral roll, huge problems in Vanuatu, needs to be redone and computerised. And as well, there's a number of things that need to be reviewed in the Representation of the People Act. And we should be introducing laws relating to political party registration, disclosure and accounting, so how they're spending their money. Now, this here, I'm not saying, the NIS is a starting point for discussion as well. It's a huge report, it covers so many things, but in some ways it's quite superficial. So I'm not saying that any of these things are the solution. Two things with how you can use the NIS. First of all, with developing the recommendations and the weaknesses. So when the team was doing this research, we didn't go in cold. Instead, Transparency International globally gives us a framework with a list of questions that we need to answer in order to analyse the performance of various institutions. You can duplicate that research using the same list of questions in your jurisdiction. Of course, you wouldn't do the entire list of questions, but you might just take some of the questions in relation to one institution. So that would be an example of using a framework to do your own evaluation of challenges. You've only got 2,500 words, so you're not necessarily looking at challenges plus solutions. You can also take the recommendations that the Vanuatu NIS has made and expand upon them and analyse them in your own jurisdiction. And here when I say take the list of recommendations, I don't mean look at the entire list, go through the list, look at one or maybe two recommendations that you think might be appropriate for your jurisdiction, and then expand upon them in your jurisdiction. So going back to your issues with legislatures and then how you could use frameworks to look at them. Parliamentary equality and accountability. You could use the NIS solutions from Vanuatu to see if that actually work in your jurisdiction. So re-examining standing orders, capacity building, a system-wide shift from personalisation of politics to rationality are things you could take from the Vanuatu NIS. MPs' educational qualifications, well, this is a possible solution to problems of quality and accountability. Another research idea that I'd like to emphasise here is empirical research using Hansard's. In order to establish that there are actually issues of quality of debates, right now we're relying on anecdotes and claims. So far, there is no published research that I've seen actually analysing the debates within Parliament. I've started doing this in Vanuatu with a very simple counting how much time has been spent debating each bill. But that's certainly useful research that no one has done yet to establish issues with parliamentary quality. We're looking about parliamentarians reflecting policies they were elected to carry on with and the current electoral system. Again, you can look at the NIS solutions in Vanuatu and see how they would apply in your jurisdiction as potential topics. Other ideas, Transparency International globally had this idea of a contract between candidates and the electorate that Transparency International Papua New Guinea had picked up on. This is going back about 10 years ago. Of course, these contracts are not legally binding, but what they are about is developing a clear commitment. I find them really interesting. Just an idea. Other research ideas, examining electoral petitions is a rich place of research, and as well examining changes in electoral laws. So I think Samoa's had a number of changes, I know Samoa has had a number of changes in electoral laws. First of all, regulating the giving of gifts, what's a customary gift that's legitimate and what is bribery, and then regulating the person's connection with the electorate to make sure there's a legitimate time. Really interesting stuff. These issues of eagerness or maybe lack of eagerness to pass sensitive bills in Parliament and corruption, look, the Vanuatu NIS, these are system-wide solutions. But as well, you can use the questions from the NIS framework to do the research to establish the nature of the problems in your jurisdiction. Other research ideas would be tracking examples of self-interested laws. So analysing constituency development funds, analysing MPs' allowances. The Vanuatu Official Salaries Act is the most amended law in Vanuatu's history, where they keep on creating new positions and creating new allowances and giving more and more and more and more money to themselves in various ways. No one's ever actually tracked that and written it down. So that would be another research idea. Now, the one on legislative power being vested in both the Parliament and government, so which is more effective, I thought, well, this isn't covered by the NIS. Research idea here, if I was doing this, I'd do some empirical research on the amount and also the nature of delegated legislation being made. And I'd maybe choose some time periods. So I'd compare 2015 to 2005 to 1995, maybe, or going back to a period close to independence. To be seen is more delegated legislation being used, is more power being delegated, in order to be able to establish if there is even a potential problem here. In Fiji, the differences in lawmaking and the use of delegated legislation between the military period and the democratic period would also, I think, be really quite interesting. No one's done this research. And it is about maybe counting things, looking at the legislation, looking at what's there, to see, is there actually an issue? You've only got 2,500 words, so you don't need to be solving a problem. But doing research to establish, well, this might actually be a potential problem that is undermining legitimacy of the rule of law more broadly, is interesting. Continuing on, your issues with legislatures, who drives change? The NIS framework isn't going to do that, but as I've already said, interactions between sovereignty, regionalism and internationalisation are really interesting. And Hassel, quoting Habermas, gives you some of that groundwork for sovereignty. Pressures to conform are also really interesting. Gender, there's some interesting case studies here. The Samoan experience of seat quotas, the Solomon Islands experience of candidate quotas, the Vanuatu experience of seat quotas in municipal elections are all case study examples. Huge amounts to choose from. One of my pet issues is consultational deliberation in Vanuatu. And all of this constitutional referendum stuff, I think some of it's missing the point, really. And I think some of it's missing the point deliberately, where MPs want to tinker on the edges, but not actually make the true substantive changes. Very simple change would be to the standing orders. At the moment, there's a short time frame for bills to be made public to the MPs, only 7 days, and there's no requirement for bills to be made public. There's no use of select committees required, and there's no requirement for time frame delays between first reading, committee of the whole House, and second reading. Changing the standing orders would be a really simple way of sorting this out, it seems to me. That's just, I'm throwing that out as a personal area of interest. Other issues, strengthening political parties, of course, is interesting and very difficult, and the impact of instability on consultation deliberation, which is possibly my Hansard empirical research, which I occasionally make it down to Parliament and sit in the library and just count the Hansards. Fiji, voter education, the electoral decree, I find really problematic. Custom and bribery, the Samoan 2005 amendment was really interesting. Kiribati laws. This is just a region-wide problem. There's so much case law on this, as well as statute law. So, if you were going, well, I haven't started my essay yet because I really wasn't sure, I have no idea of topics, that's been about 50 potential topics and potential research approaches on Parliament, which we can see Parliament also crosses over with the executive. Parliament also crosses over with the electoral system. Parliament also crosses over with political parties and connections with people. So there's many ways to look at this. Now, courts is the next area that you can look at for research. Less issues came up here. So there did seem to be one theme to do with courts as a check on the legislature and the executive. So Solomon Islands High Court ruling the tax-free law was unconstitutional. The Vanuatu court finding 14 MPs guilty over bribery. But as well, proper court procedures not being taken when passing legislation or in Parliament sittings. Quality of justice as well seemed to be a concern. Some of this was about sexual offences and sentencing. Some of it was about the interaction between customary reconciliation and court orders, what actually leads to best justice, and as well the application of human rights conventions in Pacific Island courts. Independence was also a theme for a couple of people, and the separation of powers. Of course, independence goes back to the ability of the courts to act as a check on the legislature and executive as well. And then there was some generally about court operations, accessibility of the courts, cost of the courts, low numbers of the judiciary, inadequate funding, inadequate court facilities, delays in cases, number of pending cases, and as well the legal professionals' code of conduct, which I'm really pleased to see up there, because of course how lawyers act affects greatly how courts in a common law system are able to act. I found this interesting. All of these statements here are statements of fact that need to be established. So all of them could be turned into research questions. So the statement, the court system is inaccessible to citizens of Vanuatu, especially those in rural areas, could be turned into a research question. Is the court system in Vanuatu inaccessible to Vanuatu citizens, especially those in rural areas? Or do citizens of Vanuatu find it hard to access courts due to high court fees? Rather than this being a statement, turning it into a question. And then that gives you your research topic. Problem is, some of those would be very hard to research without doing field research. None of you have been trained in research ethics, so field work isn't the best idea. The NIS indicators, the questions from the NIS framework might give you a way to explore at least some of the resource issues without having to get into quite difficult research. Again, a whole bunch of really good research topics here. The other resource is the Vanuatu Judicial, I can't remember what it stood for, Vanuatu Judicial Monitoring Study, I think, on delays in court processes. Now, this was from 2013, and since then, things have changed quite a bit in the courts in Vanuatu, which is great to say. But the research is still there because it does show a way of approaching the research, where there was a combination of case studies, court observations, but using the court decisions themselves. I was really pleased to see issues of professionalism being an issue affecting courts, because it's really easy to blame the courts for delays. But as the VJMS report showed, yep, whilst the courts did contribute to delays, about half of the reasons for delays in court processes were caused by lawyers or clients or the parties themselves. And so certainly the link between legal professionalism and the operation of the courts is really, really big and important. So with these court operations questions, if you're wanting to research this, you might go, well, can the VJMS be at least partially replicated? And maybe what you could do is review cases in a particular time period for evidence of delay or causes of delay. You might also want to focus on specific types of cases. So, for instance, criminal cases, or land cases, or family cases, and so on. Other approaches to your issues with examining the quality of justice, about sentencing, empirical research using case law on Packley. We don't have enough research on sentencing at the moment. So if you say courts are reducing sentencing, this is a question. Are courts reducing sentencing? In order to answer that question, it's simply a matter of going through case law. If you're wanting to see maybe how to do this, there's the Winu case note on the JSPL from 2015, could be useful, and as well Patterson and Jowett on the JSPL provide case surveys on customary reconciliation and sentencing. So don't feel you have to start cold. You can look at other examples of empirical research and maybe copy some of the ideas from that. The last one, improper court procedures when passing legislation or even in Parliament sitting. Again, there are questions here. What are the proper court procedures when passing legislation? Are they being followed? And what should they be? So you've got the proper procedures in law, you've got the proper procedures in practice, and then maybe the ideal proper procedures as well. And when it comes to inquiring into Parliament, does court have the jurisdiction to inquire into the activities of Parliament? And should it? So Vanuatu, there's case law which has said, yeah, courts have jurisdiction at least up to a certain point. Nauru, Fiji, they've said no, courts don't have jurisdiction. Fiji's is older case law. We don't have anything under the new constitution yet on this, because no one's taking the matters to court. But they're really interesting questions. It's been in Vanuatu's law for a very long time. I don't know the reason why it has been in law for a long time, but I would hazard a guess that transparency can be seen as threatening, because once things are transparent, it opens up avenues for people to question leaders. And in general, and maybe even more so in a Pacific cultural environment, questioning of leaders tends not to be a very popular activity. There's also political will issues. Leaders don't want to change things because leaders are really happy being able to operate without accountability. Pardons have always existed in the English common law system. So they're part of a really long tradition, but there's also a history across a number of Pacific countries of pardons being misused. So when I first came to Vanuatu in 1997, there was a tradition for pardons around Independence Day or Christmas Day, when everyone would be pardoned regardless. And so we'd be getting 30 to 50 people released. And eventually this practice stopped because it was seen as really problematic. I seem to recall, my memory might be faulty, of similar instances happening in Solomon Islands as well, with pardons being used because prisons were getting overfull. I could be wrong about that memory. At least part of the issue for me, I think pardons do have a place within the criminal justice system, but it's the manner in which pardons are exercised, and giving the power to a single person without any requirement as to processes and any kind of check on those processes, I think is somewhat problematic. Now, whether it's possible to design a pardon system where there's almost a board making decisions and there's various factors that need to be taken into account, including the risk to the public if this person is released, which for me is a really big standout. Whether there's a middle ground that can be taken there. Okay. And so I think that sounds like a couple of interesting potential essay topics as well. Other questions? And on that first one of why a cabinet minute's secret, if you were only looking at Vanuatu, there might not be a lot to say. But there might be comparative analysis across a number of countries. And then if you find out that Vanuatu's the outlier, it strengthens the case for legal change. Or policy, there's the Right to Information policy. We still don't have the Right to Information Act. It's still sitting in bill form. Kind of like Solomon's won't pass its anti-corruption legislation. Vanuatu won't either. But that would be another tie-in there.